The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
We're on the record in week 5 of the Karen Read murder retrial. I'm Cody Thomas, and this week the Karen Read retrial takes a sharp turn. A forensic expert admits he lied about his qualifications. A critical piece of vehicle data was missed entirely, and a neurosurgeon suggests John O'Keefe's fatal injury might not have come from a car at all. The prosecution is still building its case, but the cracks are starting to show.
The death of John O'Keefe was tragic. A brave officer raising 2 children as a single parent. Now, his girlfriend Karen Read has been charged with his murder, and the case has been clouded by controversy surrounding surveillance videos from the night John died and the investigation which followed. Some videos don't exist. Some have gaps in time, and others are just not 100% clear. In a case where each side has a completely different version of how John O'Keefe died, evidence from videos should help the jury find the truth. During the first trial, the jury was divided and could not agree about what happened. But now, second time around, both sides are hoping their side's interpretation of these videos will persuade the jury. Meanwhile, the public waits as the evidence unfolds inside the courtroom.
Today's testimony zeroed in on digital forensics and DNA analysis. Digital forensic analyst Shannon Burgess dropped a bombshell. An SD card, the SUV's equivalent of a black box, was missed during testing, and parts of the car's data system were damaged in the process. Burgess analyzed a 3-point turn and a reverse maneuver by Karen Read's Lexus, timing it just seconds before O'Keefe's last phone activity. But then came the twist. On cross, Burgess admitted he falsely claimed a college degree on his resume. A forensic analyst with no diploma, testifying in a murder trial. The defense jumped on it. DNA experts also took the stand. A hair found in Read's SUV couldn't rule out John O'Keefe as a contributor, and comparisons were made to Sergeant Yuri Buchanan and former trooper Michael Proctor.
What was your role in the testing in this case?
Yes, so my role was to analyze the DNA profiles and then do the comparisons.
Now, what items specifically did you receive for DNA testing in this case?
So yes, like I mentioned, we received the hair, we received the 2 reference samples, we received an extract from a taillight, as well as the negative control that was associated with that. And then we also received a reference profile from the state lab.
Now, sir, in your comparison analysis between the taillight sample and the known standard from John O'Keefe, what conclusions did you make from your analysis, or comparative analysis between those two?
Between John O'Keefe and the mixture profile, John O'Keefe could not be excluded as a potential contributor to that mixture profile.
Now, in your comparison analysis between the taillight sample and the known standard from Michael Proctor, what conclusions did you make from your analysis there?
Yes, so he could not be visually excluded, again, based on that initial comparison. So we run the statistic, and it was 76,000 times more likely that it was 3 unknown unrelated individuals versus Michael Proctor and 2 unknown unrelated individuals. And that would be strong support for exclusion.
Sir, are you familiar with some mitochondrial DNA testing that was performed at Bodie on lab case number CCA 2416-0023 pertaining to this defendant, Karen Read?
Yes.
Did the Bodie lab also perform mitochondrial DNA testing on the known standard from John O'Keefe?
Yes.
And did you then perform your own comparative analysis of those 2 mitochondrial DNA profiles from the hair extracts from the rear panel of the defendant's vehicle and that of the known standard of Mr. O'Keefe?
I did.
What conclusions did you come to from that comparative analysis between those 2 standards?
That John O'Keefe could not be excluded as being a source of the hair sample.
You're not saying that the hair belonged to John O'Keefe, correct? That's not what you're saying.
What I'm saying is, based on the genetic data obtained from the hair sample and the genetic data obtained from the known reference sample of John O'Keefe, I could not exclude John O'Keefe as being a possible source of the hair sample. In addition, all maternally related individuals could not be excluded as being a source of the hair sample.
Another way of saying that, Mr. Miyasako, is to a reasonable degree of scientific certainty, you cannot say that hair belonged to John O'Keefe specifically, can you? Yes or no?
No, with mitochondrial DNA, you can't say that it is per se an individual person, so it's more so the maternal line.
Because the hair could have come from his mom, it could have come from his maternal nephew, or anybody in his maternal line, correct?
Correct.
Were there certain events that you were focused on relative to the data in the defendant's Lexus?
Sure. So there were specific events that we were looking for specifically. That would be including time-stamped ignition-on events or power-on events, as well as other data.
Can you tell us what this is?
Sure. So this is the first power-on event after 12 o'clock on January 29th. That power event is happening at 12:36 up here in the top. And the vehicle is powered on and it's not powered off until 12:42:08.
Did you analyze it to see how, in fact, accurate it was?
Yes, I did.
And how accurate was it?
It was accurate to the second.
These two clocks, one on the left being the Lexus clock that reads 12:23:38 a.m., and the other clock on Mr. O'Keefe's iPhone has a different time, 12:23:59 to 12:24:07. Do you have an opinion, to a reasonable degree of scientific certainty, if these two clocks pertain to an event that's happening at the same time or a different time?
Yes. So these two clocks are, we are synchronizing these clocks to an event that is happening at the same time.
The Court TV podcast will return.
The Commonwealth's digital forensic analyst Shannon Burgess returned to the witness stand for a second day of cross-examination on day 19. The defense zeroed in on a 21 to 29 second time variance between Reed's SUV and O'Keefe's iPhone, a gap they say could weaken the prosecution's timeline. Burgess insisted his analysis pulled from that missed SD card was accurate to the second, but under pressure, he admitted the SUV's recorded, quote, trigger events like shifting gears don't prove a crash happened. Prosecutors tried to shift the focus back to the data. They also played a clip of Karen from an April 2024 interview where she seemed to estimate O'Keefe's time of death in line with the prosecution's theory.
Mr. Burgess, once that timeline crosses into midnight, it's January 30th, not January 29th, correct?
Correct. Yes, it is January 30th. Yes.
So in actuality, these five timelines, as you testified to them yesterday, are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are still accurate to the second.
But the date, these five timelines, let's pursue this. These five timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th. If I misspoke and said the 29th, yes.
Okay. You understand my point?
Yes, I do.
In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the tech stream event 1162-2 in your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 1162.2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
Despite claiming the purpose in your January 30 report of, quote, identifying timestamp discrepancies, potential clock skew, and clock drift, you did not compare the time of the 3-point turn between the infotainment system in the Lexus SUV and Mr. O'Keefe's phone, did you?
Not at that time, no.
You failed to apply this variance to the infotainment time on the Lexus associated with the text stream event 1162.2, correct?
Correct. May I explain?
I will proceed along. I'm sure if Mr. Brennan has questions and wants you to explain, he may choose to do that. This is simple arithmetic, is it not? It's either an addition or a subtraction, the offset, correct?
Correct.
And yet, in your initial report on January 30th, 2025, you did not take that final analytical step, did you?
No, because these clock variances do not apply to that time frame.
Is the reason you failed to take that final analytical final analytic step we've been talking about in your January 30 report was because you knew if you did that if you calculated the actual time of the 1162.2 text stream event based upon your own methodological analysis of the clock skew, there would always be continued interaction on Mr. O'Keefe's phone after the text stream event.
No.
So you deny that?
Yes.
Now, back to the Court TV podcast.
Day 20 began with an unexpected delay. Judge Beverly Cannoni spoke privately with jurors for over an hour. No one was dismissed, but 2 jurors were reseated. The judge reminded the panel no talking about the case inside or outside the courtroom. Neurosurgeon Dr. Isaac Wolf told jurors that O'Keefe's injuries could have been caused by a fall, not a car. He said the trauma was consistent with someone falling backwards and hitting their head on something hard like the ground. Then trace analyst Christina Hanley testified that plastic fragments found on O'Keefe's clothes were a possible match for Karen Reed's Lexus taillight or a similar vehicle. But the defense hit back, noting glass on Reed's bumper didn't match a cocktail glass collected from the scene.
You reviewed a number of items of information in this case. Did you have an opportunity to review photographs of a laceration to Mr. John O'Keefe's head?
Yes, I did. What we're seeing is an approximate 1.5 inch laceration with bridging tissue and contusions and abrasions. To us, that's just a classic blunt trauma injury.
So can you walk us through what happens when someone incurs this type of injury to the back of the head?
What happens is, you fall backwards, and the linear acceleration starts to take you back down with gravity. The skull hits the ground. It gets, in layman's terms, smashed a little bit. The brain is being thrust forward at a fairly good speed, and it's getting bruised. You can think of it as if you took a hammer to your thumb. It's really turning black and blue.
Could this type of injury happen from an attack by a weapon, like a bat or a hammer?
Well, he did not have a depressed skull fracture. So any focal hit like that would more likely than not have caused a depressed skull fracture.
I want you to take us back now to after the fall. Would Mr. O'Keefe, in your study and opinion, have died immediately?
No. There is very few things that you head injury where you would die, quote, immediately.
Was there any other observations you made about Mr. O'Keefe or his body that support your opinion that he didn't die immediately?
Well, the medical examiner took pictures of his periorbital area and diagnosed raccoon's eyes. So raccoon's eyes occur because there's leakage through the orbital fractures into the periorbital space. Normally, it takes about 24 to 48 hours to develop. It has been noted as early as 1 to 3 hours, which would make it not immediate.
You testified about raccoon eyes. The medical term for that, sir, is ecchymosis, right?
Correct.
And ecchymosis, raccoon eyes, does not cause a laceration to form on an eyelid, does it?
No.
Are you aware that Mr. O'Keefe had a laceration to the outside area of his right upper eyelid?
I am aware that the ME described that, yes, sir.
From your comparison of, starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the tail light, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight or from another source with the same characteristics.
And with reference to the red plastic from item 7-18.18 from Mr. O'Keefe's clothing, in your comparison of that red plastic with the red plastic from the passenger side taillight of the defendant's vehicle, item 3-1, what did you conclude from that analysis?
So the red plastic that I sampled from item from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight. So accordingly, the red plastic from item 7-18.18 could have originated from the red plastic that I sampled from the taillight or from another source with the same characteristics.
This case is a collision of science, suspicion, and the stories people tell, and the truth is still buried somewhere in the middle. The defense will begin its case soon, and if Karen Reed's team is right, they're about to flip the Commonwealth's narrative on its head. And we'll be there for every turn, every objection, every revelation. I'm Cody Thomas, and as always, thanks for listening. Stay safe, stay informed, and we'll see you next time we go back on the record.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.